after 27 weeks and 4 days. We are now just minutes away from finding out if those LMPD officers will be facing criminal charges, John.
We want to get over to our analyst here in studio, Leland Hulbert. He's currently a defense attorney. He's been a prosecutor. He's worked in family court, all facets of law. So, Leland, the fact that there's going to be a reading by the grand jury, take us through how this works and what leads you to believe there may be some charges in this.
Well, typically when there's a no true bill, meaning a grand jury finds back in their proceedings that there should be no charges, those charges aren't listed and presented in open court. In other words, the defendant that's never charged has a right to privacy on what he may or may not have been charged with. In this case, at least the signals are that there's going to be something presented to a judge at 1:15, so that makes me think that it's more likely than not that there could be charges, but obviously I have no information on that. I'm not 100% sure, but if there's something presented to a judge, it's probably more likely charges rather than just a no true bill.
Okay, so Detective Brett Hankinson is the one who was fired. LMPD said that he shot 10 rounds blindly. He has appealed his firing, though. What kind of charges do you think that he could face?
You know, without having all the evidence, basically, if he fired multiple shots, the wanton endangerment first degree has always been thought of as an example of shooting into a crowd. If someone shoots into a crowd but no one is injured, then it's wanton endangerment in the first degree because you are taking a risk that's unjustified and you are injuring potentially other people. But no one is injured, so it's wanton endangerment instead of a manslaughter, homicide type offense. Whereas if someone is actually hit by your wanton conduct, then it could rise to the level of a homicide charge.
Leland, I've been wanting to ask you this question here.